television, we're still a three-judge panel. Judge Hugg, who could not be here in person, is with us by our video hookup, and you can see him on the monitor right there. Good morning, Judge Hugg.
Good morning.
And he will participate just as if he were with us in person instead of with us virtually. So we will take the cases in the order listed on the calendar. I note only that the second case of Johnson versus Ashcroft has been submitted on the briefs. So the first case for argument is Sagaydak versus Ashcroft. Ready to proceed.
Good morning, Your Honor. My name is Tom Youngjohn, and I represent the petitioners in this case, Victor and Natalia Sagaydak. Before I get into a summary of the arguments of the case, I did want to get out one point, and that is if the Ukrainian government had done anything at all, had lifted one finger to ensure the safety of my clients, they would still be in the Ukraine. Most importantly, with respect to the merits of the claim, the BIA erred when it failed to find a nexus between Mr. Sagaydak's claim and one of the 5 protected grounds of asylum eligibility. Specifically, the BIA erred in failing to find that he will be persecuted not only on account of imputed political opinion, but also because of his membership in a particular social group. That social group is that of tax inspectors, or, for that matter, any type of government investigator. Mr. Sagaydak has a well-founded fear of persecution because...
Let me ask you a few preliminary questions. Doesn't Mr. Sagaydak have a timeliness problem with his application for asylum?
That is a charitable way of phrasing it, Your Honor. His former counsel, now disbarred, no longer an attorney, failed to file his asylum application within the 1-year deadline that she was required to do so. And that, I want to address one point. The response to, or the answering brief of the John Ashcroft, of the respondent in this case, the answering brief indicated that the date on the asylum application was November 18th, 1998, and that's at page 5 of their answering brief. However, at administrative record page 701, we find that the asylum application was actually dated February 13th, 1998. And this court can only, generally speaking, this court cannot review asylum cases if they're not filed within the 1-year deadline.
And this one was not filed within the 1-year deadline, right?
Right.
All right.
That's absolutely correct.
So what do you want us to do?
Well,
I thought there was an issue here with that there's a 1-year, there's an exception to that 1-year bar.
that is true.
Exceptional circumstance.
Exceptional circumstances.
As I read the record here, it appeared as though you asked the IJ to consider waiving or extending the deadline because of the alleged ineffective assistance on the part of counsel.
Yes.
As an exception. And it appears that the IJ did not address that particular request. Is that right?
That is correct.
Now, what if we were to agree with you? What happens?
Agree with me on that particular point that it wasn't that it wasn't timely filed, or that there was a nexus.
The IJ did not address that particular issue. That is your request.
Well,
to extend it for exceptional circumstances.
Well, not under. I wouldn't. Exceptional circumstances was the remedy really for the immigration judge. I don't believe that this court, at least through the legislation, can catch this case with the exceptional circumstances legislation.
How about when they don't make a determination? When there is no determination?
Well, in that case, there is something called equitable tolling, which this court can use. Equitable tolling is used to stop a limitation period from running. We've listed the SOCOP case, for example. It is possible for this court to toll the time period.
Is it possible for us to toll it, or is it possible for the BIA to toll it?
It's possible for this court to toll it.
Let me ask you this. Did you raise that tolling issue with the BIA?
With the BIA, I raised exceptional circumstances, because exceptional circumstances is the relief that the BIA could have. The BIA had the authority to use exceptional circumstances to go ahead and find that the asylum application was either timely filed, or at least because of exceptional circumstances, the BIA could address the merits of the claims. However, the BIA failed to so exercise its discretion in that regard.
You see, Mr. Youngjohn, here's the problem, I think, under Ventura. One, you're asking us to review, aren't you, the merits of the asylum claim, right?
Yes, Your Honor.
But the petitioner was, in effect, thrown out of the BIA because he didn't meet the timeliness requirement. In other words, right, the agency held that he's barred by the 1-year statute. And you're saying he shouldn't be barred because of equitable tolling or something like that. And shouldn't the BIA consider that first, and then before we consider that?
Well, the BIA should have considered exceptional circumstances, and they said...
but they never did they?
Well, they said that we don't even... Yeah, that's the funny thing. They said when we did the motion to...
It's a funny thing, but my question is this. In light of the fact that the BIA never considered that argument, I mean, shouldn't we send it back to the BIA for them to consider it?
That would be one relief that you could provide for the situation, to remedy the situation. Yes, Your Honor.
Now, he has also another claim, doesn't he?
Yeah, well, his... You mean with respect to the merits of his claim? There are two ways that a nexus can be found to one of the 5 categories for which he could find relief. And the first would be imputed political opinion, which the immigration judge never discussed, although the immigration judge should have discussed it. And the other way that a nexus can be found between the persecution that my clients faced and one of the 5 categories, 5 protected grounds of asylum eligibility, would be his membership in a particular social group. I would like to address right now the first of those, the imputed political opinion. Mr. Sagaydak has a well-founded fear of persecution because his persecutors have imputed to him the political opinion that he supports the government and is against his persecutors. First, Mr. Sagaydak has established that he has been a victim of persecution because he credibly testified that he will be harmed by the individuals who he named as having committed tax fraud. His life was threatened, his wife was assaulted and later miscarried, and shots were fired at a car his cousin was in. He's established that he holds a political opinion that he was employed by the government and did his job as a tax inspector. Third, he has established that this political opinion is imputed to him by the persecutors. In Aguilera-Cota versus INS, the Ninth Circuit held that, quote, "It is not crucial whether the individual actually espoused the views of the government or whether he was a high-level or low-level employee. What is determinative is what the persecutors thought." There's another quote in that case that I believe is very...
I don't know if you should spend too much time just quoting from these cases. You only have 56 seconds left, you know.
Thank you, Your Honor. I appreciate that. The immigration judge's decision was not correct because it did not address Mr. Sahaydak's claim of ineffective assistance of counsel. It failed to find that he was persecuted on account of political opinion and his membership in a particular social group. It failed to shift the burden to the Immigration Service to demonstrate changed circumstances once Mr. Sagaydak proved past persecution. It failed to recognize that the persecution can be inflicted by non-governmental actors. All of these errors are material to Mr. Sahaydak's case because they resulted in denial of his claims. Petitioner requests a grant of asylum or withholding of removal, or the remedy which the court earlier suggested. In the alternative, we request that this case be remanded to the BIA with direction that it remand the case to the immigration judge for a grant of asylum or withholding of removal. Thank you, Your Honor.
All right, thank you. We'll hear from the government now.